This Honorable Court of Appeals of Tennessee is now in session.
Good morning, Council. Before we start, just hope you all are staying safe and warm in that part of the state. If we should have any technology problems for any reason, we'll just take a pause and we'll work through them. Mr. Hivner, call the case, please.
Commercial Painting Company, Inc. versus the Weitz Company, LLC, et al.
We'll hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Phil Beck, and I, along with Jeff Smith, have the honor of representing the appellants, the Weitz Company and its sureties. I have reserved 5 minutes for rebuttal. We respectfully submit that you should overturn the decisions of the trial court in this case because the trial court erred in various respects, all of which involve a failure to correctly apply Tennessee law and to apply and enforce the governing contract. This case arose as a garden variety commercial construction contract dispute. The plaintiff, appellee, Commercial Painting, entered into a written fixed price subcontract with Weitz to perform the drywall work for a project in Germantown, Tennessee. The rights and responsibilities of the parties are governed by that comprehensive integrated subcontract, which included, among other things, provisions anticipating and addressing possible changes to the scope of work and possible changes to the project schedule. The existence and the terms of the subcontract bar any recovery in contract or in tort, with the possible exception of the recovery awarded in the first trial. Commercial Painting wants to have its cake and eat it too by relying upon the contract provisions that support its claims while simply ignoring other key provisions. The complaint Commercial Painting filed in August of 2006 alleged breach of contract and sought damages of approximately $1.9 million. It asserted no tort claims and no claim for punitive damages. The judgment, which is now on appeal, resulted from a jury trial in which essentially the same evidence and the identical damages that were presented in the first trial were presented again, but with multiple legal labels attached. The Chancellor's final judgment adopted the jury verdict and also awarded additional amounts, such as prejudgment interest, which are expressly prohibited by the subcontract. The Chancellor, without even allowing a hearing, and we submit in violation of the Lakeside Rule, simply signed Commercial Painting's proposed judgment verbatim, with one exception. The word "is" was changed to "constitutes" on page 42 of the judgment. The judgment awarded Commercial Painting approximately $8.8 million on a $3.2 million contract. $456,000 of that $8.8 million had already been paid by Weitz following the first judgment, never repaid by Commercial Painting, plus post-judgment interest at a rate higher than the statutory maximum rate. Moreover, the judgment included $3.9 million in punitive damages in this commercial contract dispute, leaving construction contractors to wonder whether they can rely upon the contracts they depend upon to identify, allocate, and quantify their risks if the trial court's judgment in this case is allowed to stand. The potential impacts of this case are catastrophic, leading both the Associated General Contractors of Tennessee and AGC of America to file an amicus brief in this case, which we respectfully request the court to consider carefully. Rather than simply summarize our briefs, I will focus my limited time with you today on a few key points which we submit require reversal. Point number one is that there is no way to reconcile the trial court's decisions with existing Tennessee law. Perhaps the most obvious example of this is that the jury and the trial court found both that there was a binding contract that governed the parties' rights, responsibilities, and remedies, resulting in an award of damages for breach of contract, and that there was not a binding contract, leading the jury and the trial court to award the exact same dollar amounts in quantum merit, which is strictly prohibited by even the judge's own jury instructions. Thus, as correctly noted in AGC of America's brief and AGC of Tennessee's amicus brief, the trial court's judgment is based upon two alternative and inconsistent legal propositions. Point number two I would address to the court is that the trial court's decisions violate both the economic loss doctrine, which creates a boundary between contract law and tort law, and the independent duty rule. I refer this court to your decision, your 2019 decision in the Milan case, in which this court reversed a jury verdict awarding $10 million in compensatory damages plus another $20 million in punitive damages based upon a claim that the defendants in that case had committed fraud and violated the Tennessee Consumer Protection Act, in addition to breaching multiple contracts for the sale of trucks. In an opinion authored by Judge Golden and joined in by Judges Armstrong and you, Judge McGee, you held that Milan's fraud claims were barred by the economic loss doctrine, which, and I quote, prevents a party who suffers only economic loss from recovering damages under a tort theory. You further noted in that case that the economic loss doctrine, and again I quote, requires the parties to live by their contracts rather than pursue tort actions for purely economic losses. Among the many cases this court cited and discussed in so holding was the Tennessee Supreme Court's 1975 opinion in Mid-South Milling, in which the court stated, and I quote, a contract may be negligently or fraudulently breached and the cause of action remain in contract rather than in tort. The independent duty rule also bars any recovery of non-contractual damages or punitive damages in this case, given that there was no violation of any duty that arose independent of the subcontract. In the 2019 E-Solutions case, this same court, in an opinion authored by Judge Golden and joined in by Judges Stafford and McGee, the court held that, and noted in footnote 7, that a tort action only arises when the act constituting the contract breach also constitutes a breach of a common law duty independent of the contractual relationship. As a result, the plaintiff's conversion claim in that case was barred. Everything Weitz is alleged in this case to have done wrong was an alleged violation of obligations which would not have existed but for the existence of the subcontract, not a violation of any independent legal duty. And they
excuse me, counsel, was this this work that we're actually discussing, was this extra work or was this contracted work under the initial contract?
Your Honor, the allegation by Commercial Painting that it was extra work, but the contract had a provision that allowed the contract price to be adjusted if called upon to do extra work. And they asserted that they were entitled under the contract to be paid for that extra work. So that was part of their contract claim as well, Your Honor. The E-Solutions case also demonstrates, and the Milan case, I should add, that the economic loss doctrine and the independent duty rule apply to intentional torts. With regard to the breadth of the economic loss doctrine in Tennessee, I also note that the very first economic loss doctrine case before the Tennessee Supreme Court, the John Martin Company versus Morse Diesel case, was not a products liability case, nor was the Court of Appeals decision in the Lear-Siegler case. So I think it is clear that while this may not be the law in some states, in Tennessee, the economic loss doctrine as well as the independent duty rule apply outside a products liability setting. The third point I'll make, and the last point before rebuttal, is that the commercial painting failed to take advantage of the opportunity this court gave them. In reversing the initial trial decision in this case, you did so because you felt there was the possibility that commercial painting could prove all the requisite elements for a tort. And if they did so, they may be entitled to different, albeit overlapping damages. They didn't attempt to do that, Your Honor. They failed to show reliance. They failed to show necessary elements for the tort. They admitted there was no reliance, and the only damages they offered were their contract damages. So I think I'm out of time, and I'll reserve my remaining time for rebuttal.
Thank you. We'll hear from the appellee. I believe you need to unmute.
Sorry about that. Thank you.
No problem.
May it please the court. My name is Scott Frick, and it's been my pleasure over these last 14 years to be representing Commercial Painting Company in this case. Let me begin with, I guess, we'll take that first point or that last point that Mr. Beck made on this issue about the supposed failure to show reliance. Actually, this court has already addressed that issue 4 years ago in the June 2016 opinion. The court canvassed the summary judgment record and determined and said very specifically that Commercial Painting Company had presented evidence to demonstrate all of the elements of intentional misrepresentation. And what's kind of an interesting thing about this is that because of the fact that this court had an opportunity to take a look at that issue, and as a result of the summary judgment motion that was granted, essentially this court's already made the material evidence review of that particular issue. Because if you think about it, the lens through which a court looks at a motion for summary judgment is the precise same lens that the court looks at and makes the material evidence review. If the evidence is looked at in a light most favorable of the non-moving party in the case of motion for summary judgment, the evidence is moved or looked at in a light most favorable to the verdict to support the verdict. Inferences are drawn in favor of the non-moving party in summary judgment. Inferences are moved in favor of the verdict in the materiality review. Countervailing evidence is not reviewed in a motion for summary judgment. Countervailing evidence is tossed out in the material review. And lastly, in a motion for summary judgment, the court doesn't weigh the evidence. Similarly, in a material evidence review, the court does not reweigh the evidence. So the simple fact remains that this jury, and this is a very important thing that is simply not addressed by the appellants in their argument, that the very first question that this jury answered was whether or not, by preponderance of the evidence, Commercial Painting Company had established each of the elements of the negligence or of an intentional misrepresentation cause of action. And what is additionally significant about that is that the court had taken those elements in the June 2016 opinion and had framed those to match the Commercial Painting Company case. And that was all lifted out and put into the jury verdict form. And then in response to that, the jury said, yes, the Commercial Painting Company proved by preponderance of the evidence all of those elements of the cause of action as this court defined in the June 2016 opinion. So clearly there's material evidence to support that. The next question is what question did they answer next, which was what were the damages that flowed as a result of that? And in this particular case, the jury determined that the damages were $1,729,122.46. Is there material evidence to support that? Absolutely. In my brief, I didn't present a factual background similar to what was done by the appellants in this case, where they're basically asking this court to look at the facts as if they were looking at a painting through a straw and having to identify what it is the court's looking at. And so, and through my
Counsel, before you,
yes.
quick question here.
Sure.
I mean, did the jury find that same amount of damages for both breach of contract and intentional misrepresentation?
Yes, it did. And my response to that is, what difference does it make? Because here's the thing, there are all types of delay damages that a contractor or subcontractor can present. The issue about tort versus contract, the main thing is you can get consequential damages in a tort case. Well, for us to go out and go hire additional experts to talk about the impact that what transpired out on that project as a result of the misrepresentations, because we were out on the project longer, there was extended office, indirect overhead, all of these things would have turned a 3-week trial into a 4-week trial. So I submit it's irrelevant because of the fact that we're permitted to assert different and alternative causes of action. And the fact that we presented one unified damage theory has no impact on whether or not the damages, there's material evidence to support that amount of damages that the jury awarded in this case. Again, if they're going to attack the verdict, they have to show that there's not material evidence to support that verdict. That was the very next question that the jury answered, which was, this was the amount of damages. We actually put on proof that our damages were more in the order of $1.8 million. It was $105,000. We're not sure what that deduction was for, but clearly there is material evidence to support that verdict. The rest of it just basically becomes redundant, or it's moot.
Counsel, let me ask you a question here. How did the jury or the trial court deal with the limitations contained in the contract?
The limitations in the contract aren't relevant. And because, first of all, the particular provisions that they're citing to, these provisions deal, I believe, with section 11 about contractors' termination rights. And as I was explained in detail, those limitations deal with what happens if the contract is terminated. The contract was never terminated. They are simply trying to take a square peg and make it fit into a round hole. And this is part of Exhibit 95, and it's on page 46 of 93. All of those provisions they're relying upon deal with what the remedies are in the event the subcontract is terminated, and that never happened. I would also add that the more significant problem that they have, we all learned the first year of law school, this concept about fruits of the poisonous tree. And one of the things that the appellants have just simply failed to address anywhere in their brief is the issue that there are two types of fraud that took place. There was fraudulent inducement. That was actually specifically addressed by this court in the June 2016 opinion. And then there's misrepresentation that took place afterwards when the project had started. And this court stated it as clearly as it possibly could have stated it when on page 17 of that opinion. Of course, they have been saying all along that all we did is, quote, permitted by the contract and consistent with industry norms. But here's what Judge Bennett had to say about that on this part of the opinion that he authored. And he says this on page 17, although Weitz is correct that it is entitled to supplement commercial painting's work if commercial painting is in default of its obligation, the subcontract does not entitle Weitz to cause commercial painting to be in default by misrepresenting a material fact and then sanctioning commercial painting for being in default, which is precisely what happened here. You can't induce somebody to enter into a contract and then take it and turn that against them. It's using the fruits of the poisonous tree. But there's a more fundamental problem that the appellants have with this issue about the jury verdict form, jury instructions, because there are some vague general statements thrown out about that. The problem is they didn't object. And you can't make this rather far-fetched argument that the simple fact that they filed their proposed jury verdict form is somehow constitutes some sort of ongoing objection. if you've got a problem with a jury verdict form or how the jury's instructed, you have to raise the objections at the trial. Assuming you do that, then they have to be raised in the motion for new trial. They didn't raise the objections at trial. They did not raise the objections in the new motion, in the motion for new trial. So those they're simply waived. And I invite the court to go take a look at their proposed jury verdict form. It's found at volume 12 of the record. It's starting at page 772. How can their jury verdict be formed if it's useless to the court? Because, for instance, one of the things they say in here is that Commercial Painting Company was required to prove its damages by clear and convincing evidence. Problem that I would submit that the Weitz company has had during this entire thing is that it has put on blinders to both the facts and the law. They are trying to make the law into something that it's not. They are trying to get this court to put blinders on about the facts and the law. And frankly, they are trying to get this court to take the square pegs of the facts, the square pegs of the law, mutilate it, carve it up to fit into the round holes of their case. If they had an issue with the jury verdict form, they should have raised an objection. The jury actually asked a question about whether or not they could put the same damage figure in all the blanks. And we talked about it and we all agreed that they could. Well, you don't get to tell the jury that they can do something and then turn around when they do it and bring it up as an issue on appeal, assuming that you had brought it up in a motion for new trial, which was never done. So I would submit that all these issues about jury instructions, all these, the jury verdict form, they have waived it under the rules. On this issue about the economic loss doctrine, the economic loss doctrine, when you're dealing with parties that are in a contract with one another, those cases apply to either a products liability case or it applies to a sale of goods. Even the Milan case, for example, is about a sale of goods. And here's something that's even more significant about that. The economic loss doctrine is an affirmative defense that is utilized by the seller or the manufacturer. It's never relied upon by the purchaser. So here's another thing where they're turning the law on its head, because the only way the economic loss doctrine could have any application in this case is if Commercial Painting Company had put up defective drywall and then the Weitz company sued us in contract and in tort. The economic loss doctrine would make perfect sense in a situation like that, but it doesn't make any sense. It has no application, first of all, in a services contract, but also where the claim that's being asserted is for compensation. And I would argue that their economic loss doctrine basically dispenses with the law of fraudulent inducement as a species or a variety of intentional misrepresentation. If their version of the law is adopted, you literally could take any contract containing any limitation of remedies, get a person to sign it, fraudulently induce them to enter into that contract, and then turn around and say, well, I've got this contract and it's impervious shield, and you can't now sue me for punitive damages. It makes no sense. It only applies in situations dealing with products liability where there's a defective product or goods that don't meet the buyer's expectations. All the other issues.
Let me ask you a question.
Yes, sir.
One of you, I'm sorry, I don't remember which one of you, but you used a term in your brief, a bid bust. Was that you or was that opposing counsel?
That came out of Exhibit 302. There was a document called the postmortem document, and this was the document that when they made comments about subcontractors and how they did, that they said, as to Commercial Painting Company, should be out of business by now. The other things that document revealed was a bid bust relative, and they can try to explain it all they want, but again, they were trying to get this court to reweigh the evidence. And
what's a bid bust? I'm not familiar with that.
A bid bust, Your Honor, is this. they quote a price to the owner to do the drywall work. Well, according to that document, they had underbid to the owner the drywall work by the tune of $1 million. So that's what the bid bust was about. And again, they didn't say anything about that to my client before they entered into the contract. So I'll try to wrap it up with this. I think that when the
counsel, before you wrap it up, the punitive damages was awarded under, in relation to what claim?
It was to the intent. Well, I could say it could be either the intentional misrepresentation or the contract. It doesn't matter.
That's my question, though. So we don't know what the basis for it was. One of those two.
Well, it doesn't. I would argue it doesn't matter, because even before Hodges, when you're dealing with fraud or it was kind of trickery or deceit is the words that were used in the prior Hodges days. That punitive damage could be awarded in a contract case, which again, they talk about the economic loss doctrine as a means of supposedly getting a get out of jail free card pertaining to the punitive damages. Well, it doesn't matter, because punitive damage can be awarded in a contract where fraud's involved. That was the law prior to Hodges. It's the law after Hodges. And punitive damage can obviously be awarded in an intentional misrepresentation case, which this jury found and answered affirmatively as to question number 1 on the jury verdict form.
Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. I'm going to real quickly try to address a few points Mr. Frick made, and then I want to wrap up. First of all, the argument that this court somehow conclusively found that there was reliance doesn't make sense. With all due respect, I would simply ask the court to reread its prior opinions, which I know you will do. And I would also point out that as of the time of that first appeal, there'd never even been a trial on the misrepresentation or fraud claim. So to suggest that that had already been conclusively determined without a trial is a stretch. In terms of the subcontract provisions, I would refer you to our brief, which discusses them in detail, and I emphatically deny that they have no relevance outside a termination setting. The contract is quite explicit about what damages are recoverable and which ones are not. They are relying upon the ones that make certain damages recoverable, like attorney's fees, and they are ignoring the provisions that make other damages non-recoverable. As far as the same dollar amounts for different claims, that's a little disingenuous, with all due respect. What Mr. Smith said when the court asked the question, could the jury award the same damages for multiple theories? He said, yeah, I suppose they could award 0 for all the theories. That is the definition of a defense verdict. And I don't think anyone would dispute that. There was never a suggestion that the measure of recovery for each of the causes of action is identical. I mean, clearly, for a fraud claim, you have to prove the damages resulting from the detrimental reliance on that misrepresentation. There was no effort to do that. They admit in their brief at pages 38 through 43 that they used their contract damages, the same damages they used in the first case, where that was the only claim asserted. And they tried to use that as a surrogate for their damages for every claim. And clearly, that's trying to make a one-size-fits-all set of facts or set of damages in this case. The economic loss doctrine, and again, to say that it doesn't apply to a services contract, again, the very first time the Tennessee Supreme Court embraced the economic loss doctrine was a services contract case, was the John Martin case. And this court, Your Honor, dealt with fraudulent inducement in the Milan case, because there the allegation was that the plaintiff had been duped into buying these defective trucks through a series of contracts.
And of course, that case is on appeal.
It is.
The
Yes,
Supreme Court has that case as we speak.
Yes, Your Honor. I actually watched the argument in that case, Your Honor. I do think the facts of that case were much more egregious than in this case, but you are correct, of course. In terms of fraudulent inducement, that's sort of a red herring, I would submit, because what fraudulent, and it also is the answer to one of Mr. Frick's rhetorical questions. You cannot fraudulently induce a party into entering into a contract because that becomes a basis for a rescission of the contract. One of the reasons I would submit this court, and certainly you can form your own opinion, but I would suggest one of the reasons you remanded this case in the first time was because of the possibility they could prove they were entitled to rescission of the contract. They abandoned that argument and did not ask for rescission. They traveled under the contract. The final thing I would say is in terms of the remedy available, certainly we believe the trial court should be reversed here. The question then becomes, should the case be remanded or is there a better solution? And I would submit, Your Honor, given limited time, I won't read them to you verbatim. But if you'll look at Tennessee Rule of Appellate Procedure 36A, it empowers you to do, in fact, it says you shall grant the relief that is appropriate. If you look at Tennessee Rule of Appellate Procedure number 1, second sentence, it says these rules shall be construed to secure the just, speedy, and inexpensive determination of every proceeding on its merits. We think the only way to fully do that in this case is to reinstate the initial judgment in this case. You gave Commercial Painting an opportunity to prove a tort claim and to prove punitive damages. They failed to do that, and they shouldn't be given yet another bite of the apple, a third trial to do something they failed to do in the second trial. So I thank you for your time. Thank you for your careful consideration of this important case.
Thanks to counsel for both sides. We appreciate your briefs and your oral argument this morning. Mr. Hibner, if you will adjourn court till 1 o'clock.
It's on
Recess court until 1 o'clock.
until 1 p.m.
Thank you, Your Honors.
Thank you.
Thank you, Your Honors.